I would like to introduce our speaker who will be introducing the other members of our esteemed panel members. Hoyt Kesterson, Security and Risk Architect with CNC Consulting. So thank you very much and welcome.
And the question is, okay, there we are. Hi there, everyone. Standard disclaimer, you've seen it. The only thing that's really unusual is statements made in this session are not legal advice. We encourage you and your counsel to discuss the topics covered in this. And here we all are, okay? But I'm going to get to them a little bit later. This is pictures for this. So what we're going to do, we're going to lay our scene. That's going to be my job, okay? To describe the background and what's going on. And when I'm all done with that, I'll transfer over to Judge Beeler for the call to order. And then there will be fact and expert witness testimony. And then the attorneys will do what? Arguing, legal argument. Now, here's what we do a little bit different. We don't do questions here. Judge Beeler will actually nominate you, her law clerks. And so the only people we want coming to the microphone are people to say, I think you should rule this way, and this is why. If you want to ask questions where they shoo you out pretty quickly, and normally we'd be doing this in the hallway, but some of us really want to move to the cryptographic conference so far as none of it is. So we have this great new community app, and we've already established a session on it. And I promise you, if you ask questions, I'll either answer them or I'll beat on the person who should answer them. So you'll be able to do it that way. But anyway, we want to handle this good stuff this way. And so then Judge Beeler will make a decision and commentary based on what we just done. So what's the background? We have this very advanced technical company called Technodigitronics, right? And they've got a contract with the government to produce something like a bionic bug. And this is a little insect that'll whiz around, and it spies. It's both audio and video and so forth. And every now and then it goes and visits a convenient bush, which is really a disguised station, where it will recharge and transmit the information that's been that is captured. That's what it does. So there's a contract with the DOD to produce this thing. Now, Technodigitronics is a very modern firewall, right? Very modern this, very modern that. But there's some issues. And it's the fact that some of their systems are a tad bit old, have reached end of life, and are no longer being supported by the vendor. So they're not being patched or anything else along this line. So the CISO knows this, Victoria Tootie. She's well aware. She's on defense for everything else that's going on. The problem is, of course, is that they naturally have to do compliance. They have to state that they are, in fact, following all the rules. And so there she is, and she basically checks compliance, but her fingers are crossed. And she's doing a cute little trick, because if anyone's ever read these standards, they basically say, do you have the latest patches, right? Well, yeah, the system stopped being patched 5 years ago, but I have those patches, so yes, the latest patches for them. So it's a white lie, but she doesn't like doing this white lie, and she knows we have to fix these systems. So she's been appearing in front of the board, right? Appears in front of the board saying, you know, this is what it's going to cost. And it's significant, because not only is it capital to buy new replacement systems, but they have essentially legacy applications that are used in design and so forth. And it's not really clear that those will work when they go onto this new operating system. So there's everything you know about trying to move old applications on the new systems, you know. So there's some concerns. She says this is going to cost some money and time. And the board says, yes, we agree there's a risk, that there is this risk here, but those systems aren't that exposed, and we have money, but we want to spend it on improving our environment so we can reach out and get new business. But we'll get to your stuff next year. So she comes to the board next year. She explains the same story, same reaction. We'll get to it next year. And after about 3 or 4 next years, she discovers that there's something called the False Claims Act. The attorneys are going to describe that really well, but this is my favorite Civil War legislation. And so effectively, which the DOD 4 or 5 years ago said, we're going to apply this act to people who make false statements to the governments in terms of their compliance. And so it allows her to be a whistleblower to them. It will allow her a percentage of the money that gets awarded, if there's any, and very good, the one thing that's most important, it protects her from retaliation. Even though she's an employee that's under a non-disclosure, her company can't come after it because the law says no, you can't. So she becomes a DOD whistleblower and contacts the DOD. Technically, Digitronix can't fight it because they've in fact done this, and so settles and pays a significant fine. It happens to be around $2.75 million. And although not publicly held, there are a few investors. Ann Warbucks, she's upset because, you know, if you take 2.5 million or 2.75 million out of the company, that kind of affects her return. So she is upset that her investment was improperly managed and she sues. She's not suing because they didn't patch. She's not suing for that. She argues that the company's risk process should have recognized the possibility of an insider informing the DOD of compliance problems, right? She says, you should have known that with this False Claims Act that there is an inducement and protection for anyone who might reveal the company's dirty laundry. And so here we are on April 25th in the Moscone Federal Courthouse, where we have the following people. You have Judge Beeler, that's your judge right here. And she of course, is the judge. Kristen Madigan, who's going to be the retained counsel for Techno-Digitronics. Ruth Hill-Bro, who is in fact going to be counsel for Ann Warbucks. Julie Lewis, who is in fact the expert for Ann Warbucks. And I'm Hoyt Kesterson. I will play the CEO of said company, and I'm also the Greek chorus, whose function I'm performing now. And as I like to say, hear ye, hear ye, hear ye, or oh yeah, yeah, yeah. The court is now in session.
All right, thank you. We're now going to proceed to the case. Counsel, are you ready to proceed? Just for members of the jury, just so you know, the next steps, we're going to hear brief opening statements. We're going to have examinations of the two witnesses that Mr. Kesterson has pointed out, and then we'll have brief closing arguments. Are you ready to proceed with your openings?
We are.
And in the interest of safety, speaking of assumption of risk, you may remain seated.
Terrific. Well, good morning. A powerful company defrauded and breached its fiduciary duty to my client, investor Annie Warbucks. That company is Techno-Digitronics, TD for short, a supposed technology leader with a lucrative government contract, yet it carelessly chose to hide critical cyber vulnerabilities, obtain false certifications for cybersecurity compliance, and failed to address the risks of insider whistleblowing. TD should have known it was only a matter of time that a whistleblower would come forward and DOJ civil penalties would follow, harming investors. And that's exactly what happened. Today you'll hear from our expert witness, Julie Lewis. Ms. Lewis will tell you about the Civil Cyber Fraud Initiative, an application of the nation's most powerful law protecting whistleblowers. She will tell you that this new law has been around for years and can lead to significant monetary penalties for companies. She also will tell you that every government contractor has a fiduciary duty to address the risks of cybersecurity whistleblowing because it is reasonably foreseeable if a company is out of compliance and can harm investors. Ms. Lewis will then tell you what she thinks about TD's outdated operating systems, with TD always hoping there will be money left from increasing its market share budget to come into compliance tomorrow and tomorrow and tomorrow, and TD's pattern of fraud, including falsifying compliance to the government. You will also hear from the CEO of TD, Hoyt Kesterson. Mr. Kesterson will tell you that the risks of outdated software and patches were not that bad, that the company fixed the critical issues. He will also tell you that his company could not have been expected to predict a whistleblower, as this application of the law, which has been around for years, since 2021, is still relatively new and untested. He will also tell you the company had already paid a large civil penalty to the DOJ, that the CISO got a portion of it, and that should be enough. These are just excuses. The bottom line is that TD1 should have done more to recognize that it was within the realm of possibilities that an insider could report long-standing compliance issues to the DoD. 2, that TD should have done more to protect investors like poor Annie Warbucks. And 3, that TD should have recognized that the sun would indeed come out tomorrow, shining a light on TD's shady practices.
All right, thank you, counsel. Are you ready to proceed with your opening statement?
Yes, Your Honor.
You may proceed.
Good morning, ladies and gentlemen of the jury. I represent Techna Digitronics, and I would like to tell you the rest of the story. As a government contractor, Techna Digitronics takes its compliance obligations very seriously. There is no fiduciary duty to investors to predict the risk of an insider's reporting of cybersecurity compliance issues to the government, and the company did not defraud its investors. Today you will hear our side of the story from our CEO, Mr. Hoyt Kesterson. He will tell you about an exciting drone project the company was working on for the federal government. He will tell you that when it became apparent that some software upgrades were necessary to improve cybersecurity compliance, the company took affirmative steps. We documented those deficiencies. We earmarked budget funds to make those corrections, and we prioritized fixing application deficiencies that, if exploited, would stop operations. He will also tell you that when the government did come knocking, the company did the right thing. We complied with the investigation, we settled, we paid a civil penalty. That should be the end of the story. The other side's expert is going to come in and claim that my client should have done more to anticipate the risks of a whistleblower and disclose those risks to their client, to the investor. But ladies and gentlemen, that assumes too much. It was not reasonably foreseeable that an insider would have filed a False Claims Act claim under a new DOJ civil cybersecurity initiative, and that matter would have led to civil penalties. As has already been pointed out as well, that whistleblower herself received a share of those civil penalties. She has already been made whole to the extent she believes she was wronged. Ladies and gentlemen, after you've heard all of the evidence today, we are confident that you will conclude that Techna Digitronics is not liable here and does not owe any damages to the investor, Ms. Annie Warbucks. Thank you.
All right, are you ready to call your first witness?
I am.
You may proceed. And who do you call?
I'm calling Julie Lewis.
All right.
Would you please introduce yourself to the jury?
Absolutely. My name is Julie Lewis. I'm president and CEO of Digital Mountain. I've been in cybersecurity for 30 years now. I started my career at Ernst & Young and Coopers & Lybrand, which became PricewaterhouseCoopers, doing IT auditing of systems, and eventually spent 4 years in venture capital, focused on cybersecurity. It's called data security back then, so I understand the investor side of the fence. After starting my company, we focus on expert witness and testimony and digital autopsy and IT auditing of systems. I have my CISM, I have my CISSP, I'm a certified ethical hacker. I'm on the advisory board to a lot of organizations that are relevant in cybersecurity or a member. I can certainly speak to IT auditing and compliance, as well as the investor equation of things.
Well, so impressive. And you're familiar with government contracting?
Yes, absolutely.
Yes. And you're familiar with the cybersecurity compliance certifications that contractors have to make to the government?
Yeah, absolutely.
Great. And why do these certifications matter?
These certifications matter because the systems that we're using for government need to be kept safe and also protect the public. And so the compliance is very critical, and filling out questionnaires and saying what you're doing is accurate.
And you're also familiar with the DOJ Civil Cyber Fraud Initiative?
I'm very familiar with the Civil Cyber Fraud Initiative. It's been around for 4 years now, and every company that's doing business with the government is familiar with that.
Yes, and it's sort of like this is that mantra that we hear all the time, if you see something, say something.
That's correct. And so it's absolutely, if you see something, say something. And if the system is not functional, it should be called out. And this is protecting public interest.
Right.
And this is not something that's used by a candy shop. This is the DOD.
Right.
This is
Tasked with security.
That's correct.
Now, in your experience, when you have a company like TD that contracts with the government, what steps would you expect it to take to protect itself from the risk of cyber whistleblowers?
Well, I think there's a couple steps. There's many steps, but internally doing your own analysis of your product to make sure it's secure, that you're up to date on your patches so that they're not vulnerable. This particular system had, there was hardware and software, and it was outdated, and so the company could not upgrade, and so I would have expected the company to actually run parallel with a new product and invest money in R&D as they did that to displace the current product that they knew had severe vulnerabilities.
Yeah. And would you expect that any company who was not fully compliant year after year after year after year after year, do you think they'd be aware of the risk that a whistleblower could be unhappy and maybe blow the whistle?
Absolutely. In this particular case, the CISO was constantly asking for budget to go parallel with the existing product to fix critical vulnerabilities. And that budget was over many years reallocated to sales and marketing to grow revenue, and also those questionnaires that were externally out there were not filled out. It was a black and white. They were not filled. There was fraud.
Mm-hmm. And you've analyzed a record of TD's cyber-related frauds and failures thoroughly.
Yeah, there were internal reports that this was known. Both through management, they were very up to date that there were some severe vulnerabilities. Externally, that was reported differently because they were concerned that the DoD would stop using their product and that revenue was significant to their future. And so this was a material event that should have been reported to investors. And could severely impact their outcomes.
Yeah, and they had to hide a lot year after year in order to.
It was year after year until it became that the product, because lack of patching, was no longer interoperable, and so that the company knew that their only option was to go have another product, and they didn't want to pull back because they wanted the government revenue. It's fraud. It's black and white.
So in your expert opinion, was it reasonable that TD did not recognize the possibility of an insider reporting compliance issues to the government when year after year it put things off?
Look, this was the company jewels. This wasn't some small little thing that was, running customer support ticketing, or this was the major core of their company that they knew had outdated software, hardware. The whole system was no longer interoperable and no longer could be patched, and they did not choose. Many companies face this. This is a constant issue where years go by and the product becomes outdated, and you have to sometimes scratch and start new, and run in parallel to replace your old product. And they just didn't want to put the investment dollars in.
Yes, so many companies do the right thing. But in your expert opinion, should TD have done more to address the whistleblowing as a threat risk?
Absolutely, they should have run parallel, as I mentioned, in creating a new product and keeping our country secure and our government systems. It was black and white on those security questionnaires. They said all patches were up to date. They were not.
Yeah.
Black and white.
Well, thank you so much. Your witness.
Ms. Madigan, cross-examination.
Good morning, Ms. Lewis.
Good morning.
You told us a little bit about the DOJ's Civil Cyber Fraud Initiative and how it works, correct?
That's correct.
You agree that this whistleblower initiative, it's pretty new.
I don't consider 4 years new, and there's a lot of education in companies that are aware about this. If you're doing business with the government, you're aware.
Only around since 2021, you'd agree?
Around since 4 years.
And you'd agree there aren't many public settlements with the DOJ since that time, right?
I think that's just because these things take time to audit and to vet out, and so that's correct.
Only a handful of public settlements with the DOJ under the DOJ's cyber fraud initiative.
That's correct. It's just there's a lapse that sometimes happens when an initiative is put in place and when penalties are put in place and audits are done.
Ms. Lewis, you agree that a company has to consider protecting its investors from risks. Is that fair?
That's correct.
And you'd agree there are lots of different types of risks that a company has to manage, correct?
There's hundreds of risks, and it's about triaging and prioritizing those risks.
And when we look at cyber risks specifically, you'd agree there are many different types of cyber risks as well. Is that fair?
There are many different cyber security risks, and it's about triage. But you know, this was the company Jules, and this is sold to the government, the DoD.
So you'd agree one kind of risk that companies have to manage and mitigate with respect to cybersecurity would be malicious actors. Is that fair?
That's correct. Malicious actors would be of concern.
Another would be insider threats. Is that fair?
Insider threats as well from a cyber level.
And that's just the beginning. Is that fair? Many, many different types of cybersecurity threats every company needs to consider when they're looking at their risk profile.
There are, but as triaging, this was the company Jules being sold to the DoD, and there's public harm that could happen, and it was not disclosed on a security questionnaire. And this is black and white. This is black and white. It was a lie. It was fraud.
You said harm could happen, but there's no evidence that anyone actually was harmed, correct?
I think this is more about an outdated product and lying on what you're telling the government, and false claims. So they violated the False Claims Act. This is a mission critical system that has vulnerabilities.
You saw that the company's CIO and their CISO put the needed upgrades in the company's master budget, correct?
That's correct. It's been in the budget for many years, and it's been reallocated to sales and marketing to grow the company rather than reinvest in a new product. Again, those were known vulnerabilities that were not addressed.
And Ms. Lewis, you saw that management agreed with those recommendations for software upgrades, correct?
You could agree with anything. You could agree somebody should lose weight, or you should lose weight, but different taking action on that.
You saw that some upgrades had to be deferred to allow funds for growing the business, but the recommendation to make the software upgrades, they still stayed in the budget, correct? They were still part of the plan?
Well, it's more than a software upgrade. This is a total replacement of a product because, you know, again, those patches no longer would work due to interoperability issues. So this is a material core product sold to the government.
And Ms. Lewis, in your investigation, you saw that the company did in fact address application deficiencies that, if exploited, would stop operations, correct?
Yes, because the product had become so outdated that and they haven't run in parallel with a new product that was secure. So yes, their operations would stop if they pulled it back because of those vulnerabilities.
So the company did address application deficiencies that, if exploited, would stop operations. That's fair.
They thought about it, but they never did anything about it. That's different. Again, I go back to the diet. You could go, you know, let's lose weight, but if you don't do anything about it, they would just talk about it. It was all talk.
Going back to the materials
based on the internal report.
Going back to the materials you considered informing your opinions, you saw that year over year, the CISO signed off on compliance records, correct?
That is true because the CISO, my understanding from, that is correct.
So the CISO went along all that time, years, correct?
The CISO wanted additional budget, but was in fear of, my understanding, of losing her job.
So when the CISO signed off on all those compliance reports, the company had no reason to believe that she was going to turn around and report to the government, correct?
I can't speak to the intent or what was happening. I can speak to that there was material deficiencies in the product that was live at the DoD, where there's major public interest at risk by having this product out there with vulnerabilities. Whether it happens or not, you know, some major, you know, incident, that's different, but the company knew about these deficiencies and they lied on their assessment report externally.
So she saw something, but she didn't say anything, right?
She saw something and eventually said something when those vulnerabilities became material.
Thank you, Ms. Lewis.
Thank you.
All right, Ms. Madigan, are you ready to call your witness?
Yes,
And the
Your
witness
Honor.
has previously been sworn.
Good morning, Mr. Kesterson. Can you please introduce yourself to the jury?
Yes, my name is Hoyt L. Kesterson II. I'm the CEO of Techna Digitronics.
And Mr. Kesterson, can you please describe briefly for the jury what Techna Digitronics is?
It's a company with a very funny name. It effectively is a research company. It tries to find areas that people aren't really addressing, novel techniques, and make proposals not only to DoD but to other places. And so we have multiple design projects on the air. We're a very creative company, and our focus is on the creation of new things. And we believe this drone that looks like a bug is is a new thing.
Mr. Kesterson, how did this exciting new drone product work?
Oh, well, I mean, it's a drone, but it moves its wings, so it's kind of like it's not rotary, it's flapping kind of stuff. It makes the right kinds of sounds, but it will do most of its stuff by moving to an area, waiting, observing, recording sound, and so forth. All runs off an internal battery, which gives it maybe 18 hours of operation. And then at some point, it heads off nearby, where very cleverly, something that looks like a bush, but isn't a bush, it'll go to it, it'll nestle into it, it'll get recharged, it will transfer all the information that it has recorded into that bush, be recharged, and head out again the next morning. Meanwhile, that bush at some point will be making a encrypted communications connection, and it will upload all the stuff it's recorded. So effectively, it's kind of a scout, a monitor.
Mr. Kesterson, at some point the company learned of some issues with outdated software and patching, correct?
Yeah, well, yes, right.
What were those issues?
Well, the basic problem is we, as a design company, we use this specialized software and specialized systems that our creative people and our engineers set with to basically prototype the devices that we're going to try to manufacture. We have to look at them in three areas actually. We have to look at them in terms of how well they're going to work and apply the thing, how costly they're going to be made, and can we sell them for a reasonable price? Will there be interest? So effectively, this is, I don't want to say this is the backbone because of manufacturing and so forth, but this is the start of any new project. It has to happen there. So we have these systems which for many years on other projects have been grown, but the systems, the platforms have worked very well for us to do what we want to do, but with improving technology and so forth, our hardware software vendor in this area has moved on to better, stronger, faster platforms. We don't need better, stronger, faster because they do the job. Unfortunately, they stopped supporting the product. They said, okay, well, that's it. You're not going to get any more patches. You're running the way you're running. And that was okay with us because it satisfied what we were trying to do.
What steps did the company ultimately take to address some of these software and patching issues?
Well, we knew immediately because essentially the system told us the company told us for some time they were going to end the life of the system. So we kind of knew this was coming, and then the patches stopped working. But as I said, our use of it was very stable, so it was still working. But we knew that there was this, several problems. Number one, sooner or later we might want to get on the new hardware. We definitely want software upgrade. We're very concerned about security because even though these systems don't interface externally, they interface within our network and therefore are potentially vulnerable. So we knew we wanted to fix this, but basically over the years we had cobbled together a specialized integrated set of tools running on this platform, and we were concerned that if we moved to new hardware, it wasn't going to be the cost of the hardware that was going to be the issue, although that would be a cost. It's the fact that we were not really sure that our tools and so forth would in fact work. And so now you're talking about replacing all that stuff, and since that's the kind of the starter for the bread that we make as a company, then we're concerned that this could in fact stop production, so to speak, not manufacturing in terms of evolution of the project. So we had to basically estimate capital impact. We had to estimate the amount of time we would spend internally in terms of adjusting everything, and also what changes would the people or users would be done. And when you totaled all that up, it was a significant amount of money. But we felt it had to be done, which is why we put it into the budget and explained this. And when we explained it to the board, everyone agreed. Everyone agreed that the prices were really right. Everyone agreed that this should be done. What we just couldn't agree on is when should it be done.
And throughout this time period, who reviewed and approved your compliance audits for the government?
Well, this is an issue. Ms. Tootie, basically, as our CISO, interfaced with external auditors in between our company. She was aware of the problem, and it sort of bothered her, but we talked about this a lot, and we basically agreed that the language is just as the expert for the plaintiff says, upgrade to the latest patches, right? And these products had the latest patches. The fact that they were 5 years old, latest patches, there was nothing subsequent to it, so it addresses it. I'd like to point out that very few compliance statements actually specifically talk about, please identify if you have any products that are end of life. They basically just say this. So maybe we're playing a real game here. I kept hearing black and white, black and white. It just seemed awfully gray to me.
As CEO of Technodigitronics, did you have any reason to believe that your CISO was going to end up reporting claimed cyber fraud under the DOJ Civil Cyber Fraud Initiative?
Well, I must admit that I watch football on the weekend, don't really read the law or the news from the courts and the DOJ, and perhaps in-house counsel might have been remiss, but they didn't even realize. I mean, in-house counsel was even unaware that we had this problem, so there was no communication with them. But she was frustrated, and I was frustrated because we felt this should be fixed, right? And else why we invested all the plan. But at the same time, it's very difficult. The board is sitting there and trying to allocate how the next year's budget will be spent and what they want to spend it on. It's been characterized by opposing counsel that it's marketing and so forth. Well, no, we bought all other kinds of equipment. We wanted to go after new markets. We wanted to do other kinds of things. And senior management, me included, but definitely the support and guidance of the board, felt for whatever reason that, yes, we had a problem. We didn't think it was that severe technical problem. We kind of realized that we had our fingers crossed when we did our compliance statement, but business was booming. Put more resources into our company in certain areas, so we go grab some of that business. we believe, and actually, that's an obligation to our investors to grow our company. So we may be beating up for having made a mistake here, but had we been successful and kept on going, we would in fact have improved the fortunes of the company and the fortunes of our investors.
Thank you, Mr. Kesterson.
Okay, cross-examination, and just for timing purposes, everyone should know we have 4 minutes and 30 seconds before we move to the questions part of it, so.
All right. Mr. Kesterson, you are Techni Digitronix Chief Executive Officer,
I am.
and you have a sophisticated technology company, right?
Yes, we are.
And this company you oversee came up with an exciting drone project for the DoD.
Yes, we did.
And your company collected voice and video surveillance data and had a disguised charging station to transmit data via satellite.
Well, our company didn't collect voice and data. Our product would have collected voice and data when it was deployed.
And you agreed it captured sensitive data to be used by DoD?
When we signed the contract, yes.
Yes, yes. And you agree as a government contractor, your company had to certify compliance with the certain minimum cybersecurity standards.
Yes, we're very aware of what those guidelines, what those compliance guidelines are.
But it turns out your company was not compliant, was it? Did it have outdated software?
It had, you said updated software. I will.
Outdated, yeah.
I will say we had up-to-date software as far as the vendor was concerned.
Up to date as 5 years ago. All
Yeah.
right. Failure to upgrade and patch?
We had every patch the vendor had ever given us installed.
Yeah, as of 5 years ago. Withholding information from third-party assessors?
We told them that we had the latest patches for each product.
And falsifying certifications of cybersecurity compliance?
The thing said, do you have the latest patches? And we said yes.
There just was never enough budget after going after new markets to get the cybersecurity compliance part, right?
That was the statement from the board. I
Yep.
had nothing to do with that.
And that was true, though, in 2021, right?
It has been yes for several years in a
And
row.
2022,
Yes,
and 2023,
yes,
and 2024,
yes,
and 2025.
yes, and probably 2026.
Well, you must have known that eventually years of cyber failures were going to catch up with the company.
You know,
Like cross, fingers
it's
crossed.
the way life is. You dance hoping no one will pay attention, and you'll finally fix it.
You play the game, I think you said.
It didn't happen.
Yeah, and you knew that if the cyber fraud was revealed, it could ruin the government contracts, correct? That all that money would be lost.
Well, we knew they wouldn't be happy.
But the company just didn't have steps in place, year after year after year after year after year, to recognize that risk and fix it before it happened.
Well, we we knew the information. We did a risk analysis, and you're objecting to the result and the decision that came out of that risk analysis. Risk analysis is a toss-up sometimes.
Thank you.
All right, we're going to move directly to closing arguments, maybe 2 minutes each if you can.
Okay.
You may proceed.
Well, now that you've heard all the evidence, you must decide this case. We bear the burden of proof. We must prove more likely than not, and we have more than met that burden. The bottom line is that TD owed a special duty to my client, Annie Warbucks, to manage her investment and protect it. What did this technology company do instead? They ignored the red flags. They knew the product was not compliant. They knew that compliance was key to keeping a lucrative government contract. They knew that security was very important to the Department of Defense, a government client built on security. Yet when forced to choose between profits and compliance, between profits and protecting a security-focused client, what did the company do? They all lied. He even said it, my white lies. False compliance and audit reports 2021, 22, 23, 24, 25. Knowingly delaying critical software updates and upgrades 21, 22, 23, 24, 25. Failing to take even the most basic precautions to protect investors like Annie Warbucks from the fallout of an inevitable whistleblower and civil penalties, year after year after year after year after year. Whatever excuses TD tells you, the bottom line is the company should have done more to protect my client, poor Annie Warbucks, and all of its other investors from the harms flowing from TD's years of cyber fraud and deception. There was no conceivable business justification that could excuse this breach of duty and the fraud committed against Annie Warbucks. She never would have entrusted her assets to this company, never would have bet her bottom dollar if she had known that they would be fast and loose with critical cybersecurity compliance. It didn't have to be a hard knock life for Annie Warbucks or for any of these other investors. Because TD failed and lied, Annie Warbucks has been stuck with day after day that's gray and lonely. But she has been hanging on until tomorrow, until her day in court, which has finally arrived. We ask that you find that TD is liable for fraud and for breach of fiduciary duty to my client. We ask you to wipe away the cobwebs and the sorrow and award Annie the maximum damages available to her.
Ms. Madigan, the floor is yours.
Thank you, Your Honor. I will be brief. Ladies and gentlemen, the bottom line here is that Techna Digitronics did not breach a duty or defraud its investor. Plaintiff, Ms. Warbucks, she's just looking for a payout. No one was harmed. There was no breach. There wasn't this hypothetical failure that you've heard from opposing counsel about. Whatever issues the company had with respect to its cyber hygiene and compliance, it could not have reasonably expected that its CISO, who signed off on compliance audits and business practices year over year over year herself, would suddenly turn around and report as a whistleblower to the government. The company has already paid its dues. It cooperated with the government, it paid a significant civil penalty, and the CISO got a share of that money and special protections around against workplace retaliation. In short, to the extent there was any issue, the company took responsibility, it's made amends, and satisfied any duty owed whatsoever to the plaintiff. It was not reasonably foreseeable that a whistleblower would come forward, and the company's conduct in response to that event more than satisfied any fiduciary duty owed to the plaintiff. We hope that after you've considered all of the evidence, you will find that plaintiff did not meet her burden. Thank you.
All right, well, that was the speediest trial ever. Good job. Very funny, love the Annie references. Wow, now that, you are my law clerks, and the jury is deliberating now on this issue of investor fraud, but as you know, so you're both the jury and the law clerks. They're jury now and the law clerks now, but these are legal issues that we're gonna have to consider in post-trial motions. So just by show of hands, how many think that the verdict ought to be in favor of Annie Warbucks, the investor? Okay, so that's a lot of hands. How many are going to vote for the company? And I've got a few hands up there. All right, so it's interesting, right? This isn't about the DOJ whistleblower case, or it is. The company's paid its civil penalties. The investor is asking for damages. For those clerks or jurors who think that the investor ought to be rewarded basically by having her investor fraud suit come out with a verdict in favor of her, why? Why is that a risk that why do you think that, this is sort of the Q&A part of it, but why do you think that, we should have some mics there, but there's some mics there. So why do you think that this was a known risk for the company? That a whistleblower would come forward?
This is why I wear a hat with a brim.
It's a good job to wear a hat. So we have a big room with a big light on. So yeah, come on up, perfect. So why is it
I'll take a stab, but I think that when you're investing, you're expecting the board to provide the governance, and part of the governance is not just the fiscal responsibility, but the cybersecurity and contractual responsibilities.
Okay, and you think that the board should have known that a whistleblower might come forward?
Absolutely.
Okay, all right.
Yeah.
Good. Yes, so.
So there was a civil penalty. The CEO declared that they're not going to be compliant again. So it looks like in the future they're still going to have another penalty. To me, he stated on the stand that he's not going to patch that hurt. They're not going to fix it.
Well, they may not have any money now that they've lost the Department of Defense contract. But, good point. It's an ongoing risk that the company isn't addressing. and matters to the investor. Yes, thoughts?
The company demonstrated a continuous and sustained pattern and practice of violations of the Defense Federal Acquisition Regulation Supplement, Clause 252.404-7012, 7020, and 7021.
Excellent, and they ought to be responsible as a result. Good. Well done you. Yeah. Yes.
Mine isn't going to be quite that elegant, but I mean, I think that given the context here, the company had to have at least been anticipating via CMMC that this train was going to come down the tracks at them regardless, right? That this, even given the current language, they might have been able to squeak by with a white lie, but this would have never gotten through the new CMMC, and the fact that they weren't accounting for that risk and that they were making the decision to continue to, you know, kick that can down the road, the investor was always going to have this day where that finding did come up, right? And I also have a hard time believing that, you know, this product would have had to be pen tested. And no pen test report would have said, well, your Windows 7 is fully patched, so I guess this is cool, right? So, I mean, this would have been a big blinking red light on the risk register for a long time that was inevitable. And if the loss was inevitable and not being represented to the investors, that was going to be something that was obviously going to get discovered, you know, by the latest 2026, right? I think that's fraud, right?
Can I hop something in there?
Yes.
It's interesting you said the product's going to be pen tested, but the product is the bionic bug. It's going to work. It doesn't matter that the software that designed it had flaws in having to do with security. That does not necessarily translate to problems with the bionic bug. If they were out doing an acceptance against that product, they would not gone back and tested this thing. And so I think they're separate things. I think the company, I think the company did wrong. Hey, what the heck, I'm the CEO, but it did wrong. But I'd like to make the point that anyone who's ever run a company, I have not, but I've certainly watched it being done, no one ever has enough budget to do everything.
Right, but does that calculation change when you're contracting with the government?
Well, yes, basically, as we pointed out, the flaw here is we never thought someone would air our dirty laundry.
Right, so that's the interesting little twist on this. So there's the reality of the company having a landscape, a budgetary landscape that it has to navigate. The contract caught up with it. And the issue is whether the whistleblower was a known risk, and that's why the investor is suing. Yes?
If the company truly believed that they'd done nothing wrong, then there was no risk of a whistleblower. So because there's nothing to whistleblow, right? So there's an argument there that if we can prove that they thought they hadn't done wrong, and if we believe that you know, this updating thing is fair, then there was no risk of whistleblower. It's a second order problem. And if we can prove the first is true, then the second cannot be true, I would argue.
But they did pay a fine, and that affects Annie.
Well, Annie gets a cut of the recovery,
Yeah,
the False
exactly.
Claims Act recovery. So, so anyone else want to take a stab at the issues? Stand up for the company? I think we're at time. If not, and thank you for your attention, and thanks to our players. What's that? You got a rule? Oh, well, I think it's, luckily, anyone who would pick a judge to make a decision is a fool, and it's actually with the jury. No, just joking, I'm kidding. So it's with the jury. The issue, I think, for the court would be, as a matter of law, is would the verdict come out? Should the verdict be set aside? I think probably the jury would return a verdict in favor of the investor, because I think jurors have a really hard time when you don't follow rules that you're supposed to follow, because that's what this case comes down to. And then I think the damages probably would be, depending upon what happened, it's not a public company, right? It's a private company. The investor has an investment in it, and whether it would be foregone profits or whatever, I think we do the math on post-trial motions, but I think we probably would not set aside any jury verdict in favor of the investor. Okay, with that, these proceedings are concluded.